evidence, along with many others like Rolf Harris being pretty much crushed by the press on his way into court. However, the judge and the prosecution completely ignored the fact that every other newspaper and journalist questions and photographs defendants entering court every single day across our country. But in my specific case, the Attorney General decided for the first time in British history that when Tommy Robinson politely questioned the now convicted Muslim child rapist, it amounts to contempt of court and could have interfered with the court's proceedings by leaving the defendants in an anxious state of mind. Simply ask them, how are you feeling? I knew the entire system was corrupt when the judge unbelievably agreed with the Attorney General. This has effectively set precedent. Questioning any defendant is contempt of court. Will you ever see another journalist arrested and prosecuted for asking questions or photographing a defendant entering a court? Of course you won't. Of course you won't. Because the Attorney General spent 5 months trying to invent something. Trying to invent something they could fit me up with. And therefore this will be a complete one-off, designed solely to fit up Tommy Robinson. This is a total abuse of power. Now let me address the final charge, breaching a Section 4.2 reporting restriction. Because previously I was ignorant of the rules around contempt of court, I decided to privately pay for media and contempt of court training from Kingsley Napoli, who are one of London's leading law firms. I was keen not to break the law again, and this training taught me all the rules around contempt of court, and what I can and can't say, the rules of what I can do. I also downloaded and read the judiciary's own paper called Reporting Restrictions in the Criminal Courts, which is available to download on the judiciary's own website, their website. The Lord Chief Justice himself introduces this report, stating that it's a practical guide for judges and the media on the statutory and common law principles which should be applied with regards to reporting restrictions. If you simply go on Google reporting restrictions in criminal courts, you can read it for yourself. It's the very top link. So let's start with these guidelines on the judiciary's website. Reporting restrictions impose a potential criminal liability on media, editors or journalists, and for that reason, the judiciary's guide lays down specific requirements that the court must follow in the event of a restriction. They must follow. Must! The details of any restriction must be shown on the court listing online, the court screens, and also posted on the doors of the court. Court staff need to respond positively to any request for assistance in relation to the existence of or the specific terms of a restriction if one exists. As you can see from the outline court listings the day before I attended Leeds Crown Court, they mentioned that the jury had retired, but crucially, there was no mention of any reporting restrictions still in place. This led me to think that as the trial had finished and the jury had retired for the verdict, then the restriction may have been lifted. When I turned up to court that morning, I decided to go into court and ask a member of staff if there was still a reporting restriction on the case. As the prosecution witness confirmed in court, he told me he did not know of any reporting restriction on the case and did not provide me with the details of one as is the required in the judiciary's guidelines. My cameraman also went into court and took a picture of the screen and looked at the door to the court, both of which also had no notification of any reporting restriction. The Attorney General, on reading my statement, then tried to disprove it by interviewing the manager of Leeds Crown Court. Unfortunately for the prosecution, she actually confirmed everything I said. In her words, they had failed to adhere to legal guidelines. And in fact, the details of the reporting restrictions were never even uploaded onto the court system at all during the entire trial. The contempt of court law is so out of date it was set before the invention of the internet. The high degree of confusion around guidelines and reporting restrictions led the Law Commission to conduct a 6-month review and recommendation paper back in 2014. The Law Commission found that the rules and guidelines are extremely confusing and could lead to a journalist mistakenly landing in contempt of court. Their sole recommendation from their 6-month review was that the government create one national website that details all of the trials with reporting restrictions placed. This would allow the media journalists and members of the public access to fully understand what can and cannot be reported on any restricted trials. 5 years on, and they've continued to ignore that recommendation. I'll tell you why they have not followed a completely sensible and extremely easy to implement recommendation. That is because the public would then be able to see the sheer number of these secret Muslim rape gang trials that the government are so desperate to hide. This charge is so laughable that even in the Attorney General's skeleton committal proceedings against me, it referenced a precedent from 1997. It was a case on reporting restrictions against newspaper publishing PLC, where it was decided that, and I quote, this is from a precedent, "No one should be in peril of suffering a criminal penalty for contempt unless the order which he is said to have infringed is clear." Even if I breached a supposed order, the fact that Leeds Court admitted to failing to follow up of the required notifications on the order or provide any details when I asked that day means they failed in their duty to inform me of any restriction, let alone make the details clear. The crucial point though is that all of this is actually irrelevant, and the prosecutor just used it as a distraction tactics in court because I didn't even breach the reporting order in place on that day. The fact that the trial had come to an end and the failure of the court to notify the public of the existence of an order led to me to believe it was no longer in place. Given how much the government have it in for me, I decided it would still be wise still not to risk breaching one. During my training and studying the judiciary's own guidelines, their own guidelines issued for judges and the media on reporting restrictions, it mentioned one critical point, which I followed to the letter. The crucial piece of law in the judiciary's own guide that was approved by the Lord Chief Justice himself can be found on page 27. The law states, and I quote, "Courts have no power under section 4.2 to prevent publication of material that is already in the public domain." On that day at Leeds Crown Court, I read details of the defendants and their charges from an already published BBC article that is still visible on their website today. It was material that was already in the public domain prior to the reporting restriction, and therefore, according to the judiciary's own guidelines, could not form part of any reporting restriction. I referenced this several times on my live stream and stated that I was only referencing information already in the public domain. I told Judge Marston this instantly. In the original case at Leeds, they failed to make clear any detailed notifications of a reporting restriction on the case, which according to the legal precedent would mean they cannot hold me criminally liable. But crucially, I followed the judiciary's own guidelines, which have been available on their website for the past 4 years and approved by the Lord Chief Justice himself. I only discussed information on that live stream that was already in the public domain. This information could not have been part of a reporting restriction according to the judiciary's own guide.